Okay, it's 12 noon, so I think we'll give people joining about a minute just to get online, and then we'll get started. Okay, so I think we can get started. Hi, everyone. Welcome, everyone in the audience, and thanks so much for joining us for our presentation today on Land Use 101. My name is Andrew Vogel. I'm with the California Attorney General's Office, and I'll be moderating today's panel. The webinar today and the panel is the latest in our Introduction to Environmental Law series, which is presented by the Environmental Law section and the New Lawyers section of the California Lawyers Association. The series is designed for law students and new lawyers, and even for more experienced lawyers who are looking to learn more about or get a refresher on various subject matters within the field of environmental law. Some of our most recent installments of this 101 series included 101 webinars on forestry law, drinking water law, and climate change law. And you can find many of those webinars archived on the section's YouTube page. And then coming up on October 19th through 22nd is really the environmental law section's signature event, the 32nd annual Environmental Law Conference at Yosemite. On this slide, you'll see a little bit of information about the CLA, California Lawyers Association generally, and the environmental law section. Whoops, excuse me. Go back there. As you'll see, the CLA, the California Lawyers Association, is a nonprofit voluntary organization dedicated to the professional advancement of attorneys practicing in the state. And the environmental law section is one of, I believe, 18 different subject matter practice area sections within the CLA, whose mission, as you'll see, is to advance the quality, breadth, and availability of information related to environmental, natural resources, land use, and energy law. And the New Lawyers section, as you'll see, represents all lawyers in California in their first 8 years of practice. Bear with me one second here. A quick disclaimer, though I'll be moderating the panel today, and really the panelists will be doing the real heavy hard work, just a disclaimer that I'm not here speaking on behalf of my employer, which is the California Attorney General's Office. So the views expressed here don't necessarily reflect those of the Attorney General, the Attorney General's Office, or its clients. So with that out of the way, I'll now introduce our panelists for today. More detailed information about their bios was on the section website where you registered for this webinar, but I'll summarize a little bit here. First on our panel is Helen Campbell, who is the planning director for Los Angeles City Council member Ulises Hernandez. Helen directs and guides all major development and planning related policy in LA Council District 1, which includes such diverse communities as Highland Park, Echo Park, Chinatown, Dodger Stadium, downtown LA, and Westlake Pico Union, among others. Helen has nearly 2 decades of policy and planning experience in the nonprofit, local, and state government sectors, including recently for the Governor's Office of Planning and Research, where she managed regional planning programs and co-developed land use policies and legislation at the intersection of housing, climate, and equity. Next on our panel is Ken Lee. Ken is the principal of Ken Lee Consulting, and he offers clients more than 25 years of public and private sector community development and real estate experience. Ken leads teams of planners, architects, engineers, attorneys, and financial experts in planning and executing projects while navigating local, state, and federal laws and policies. Ken currently serves as the Vice President of Development for Pacific Plaza Premier Development Group, which is an infill real estate development company in Southern California with more than 2.7 million square feet of multifamily, retail, hospitality, mixed use, and industrial projects in the San Gabriel Valley area of LA. Next on our panel is Andrea Ruiz Esquide, who is a deputy city attorney at the San Francisco City Attorney's Office, where Andrea has worked since 2007. Andrea advises different city departments and commissions within San Francisco on matters under local, state, and federal environmental and land use laws. And she has particular experience in the California Environmental Quality Act, or Sequa, as well as historic preservation, transportation, air quality, and greenhouse gas issues. Finally, we have Ryan Waterman, who is a shareholder at the law firm of Brownstein, Hyatt, Farber, and Schreck. Ryan solves complex land use, water quality, renewable energy, and hazardous substance issues in connection with development and redevelopment projects, including permitting, administrative, and litigation matters. Ryan has particular expertise with the land use entitlement process and Sequa and NEPA environmental review as part of successful projects. Before we move further, I wanted to make one sort of acknowledgement about land use laws and land generally in California. Often at legal and environmental conferences or at public meetings, speakers acknowledge that the event is taking place on land that was once unceded territory of tribes that preceded their presence there. Now, since this webinar is taking place remotely and happening throughout the state of California at the same time, before we move into the substance of the presentation, and in the same spirit, we wanted to acknowledge that the history of humankind has always been deeply connected to the land and natural resources where different social groups have made their homes. And we want to also acknowledge that the history of California itself contains many instances where newly arrived settlers dispossessed those who inhabited these lands before them, whether it was Spanish colonizers with missions and military forts or presidios, Mexican settlers, or those who came in search of gold, or more recent arrivals. And we also wanted to acknowledge that this history itself has often been violent, and that the law in the past has often been used to discriminate and exclude, from those early settlers to the internment camps to redlining and other practices that have historically exacerbated racial and social equality. So we as land use law practitioners are grappling with that history more and more as the laws begin to acknowledge some of these past practices and current ways to redress them. And you can find some more suggested readings in the materials that will be listed at the end of the presentation and listed in the PowerPoint. So moving on to the heart of our presentation, unlike other panel discussions you might have been to in the past, where panelists might give their own presentations sequentially on particular subjects, today's panel is set up a little bit differently. The panel today will be presenting the nuts and bolts of land use issues with a focus on the entitlement and permitting process at the local level. And we're going to be doing that using a hypothetical proposed development project. Taking that hypothetical, each of our four panelists will discuss the issues that this project raises from a different perspective or set of interests. Andrea will first be taking the perspective of the local jurisdiction where the project proposes to be taking place. Ken will then approach the issues the project presents from the perspective of the developer. Next, Ryan will discuss the project through the lens of an opponent of the project. And finally, Helen will give you her perspective from the standpoint of the elected city council members within the jurisdiction. After that, we'll open up the program to question and answers. So I've talked enough. I'll stop talking now, and I'll give the floor to Andrea to introduce the hypothetical project and start the presentation.
Thank you, Andrew. Thank you so much for that presentation. Thank you, everybody, for being here, and to CLA for inviting me to participate in this webinar. Slide, please. So before I get into the hypothetical, just a few words about what is land use and what is land use law. Basically, land use broadly refers to the relationship that humans have with the land. And that's something that has come, since humans have inhabited the earth. And land use law in particular is a product of like the common law. It comes from nuisance law, property law, And basically it has come down to what we know as the police power, which is this notion that local jurisdictions have authority to do anything they want, they see proper to protect the public health, safety, and welfare. And it's a concept that's been recognized by the courts many times, and that is enshrined in the California Constitution, which says that a county or city may make and enforce within its limits all local police, sanitary, or other ordinance and regulations not in conflict with the general laws. So as you may surmise from that, not in conflict with the general laws is where a lot of the nuts and bolts of our practice evolves as a member of, as an attorney advising a jurisdiction. We know where does the city power end and where does the state end, and the general preemption concepts in terms of like explicit or implicit preemption of broadly occupied field apply. There's also the federal government. So there's 3 layers of government and laws that we need to review when we advise our clients. But generally, the local police power is very broad, and land use law is one aspect of that police power. And courts will generally be deferential if there is a reasonable basis to, from the ordinance to those goals. There are some limitations, of course, such as those enshrined in constitutional rights and takings jurisprudence and due process, but generally it's a broad power. Next slide, please. And this slide just lists the kind of the boring slide that has all the laws. If you wanna, after the presentation, wanna go and check them out. I'm not gonna describe them in any detail, but we're gonna be talking particularly about the planning and zoning law and the government code and the California Environmental Quality Act. Next slide, please. So the particular hypothetical that we're going to present today has to do with housing, which is a topic that has been in everybody's minds recently, and particularly the housing element update. From my perspective, I'm going to introduce a housing element update. The housing element is a part of the general plan, which is like the constitution of the city or a county. It's mandated by the state. The general plan is mandated, and it has some elements or like topics. There are 7 mandated topics, such as housing or transportation. They're thematic topics, or open space. Recently, the state passed another law that requires preparation of environmental justice element for jurisdictions that have disadvantaged communities. So the housing element is just one of those elements, and it needs to be updated as mandated by state law every 8 years. So it's a state mandated process which is locally implemented, and the state has mandated, because housing has been such an important topic and the state is in such a housing crisis. There's lots of laws. It has been amended recently to give the state more jurisdiction to enforce, and including penalties that would eventually result in taking the police power away from a jurisdiction. The state would enforce how you implement your housing element. So this is a very crisp and important area of the law that's been in the newspapers and is everybody talking about, as you'll see later in the presentation. Next slide, please. So in San Francisco, the state starts like that. The process starts like this. The regional planning organization creates what's called the RHNA, or the Regional Housing Needs Allocation, which is a projection of how much housing is going to be needed in the next housing cycle or the next 8 years. And they do that regionally, globally. In San Francisco, it's called ABAG, the Association of Bay Area Governments. And they give each jurisdiction within that planning region an allocation. In San Francisco, the allocation is more than 82,000. So San Francisco is supposed to create room for housing for more than 82,000 units of housing within the next 8 years. And this slide is taken from our housing element. It shows how the yellow one is the new allocation and the orange one is the previous allocation. So it shows how much is grown incrementally more than 3 times. And it also shows how we've met our targets for the different income groups. The RHNA comes with the allocations for specific income groups. So as you can see, for above moderate, we've met it and surpassed it, but for all the other affordable housing groups, unfortunately, we haven't. And even though this is a kind of a not a very good outcome for San Francisco, it's much better than in many jurisdictions. Like, we have produced a lot of housing and we're proud of it. But anyway, next slide, please. So how do you go about, when you're a jurisdiction, complex jurisdiction like San Francisco, to do that, to say, how are we going to create housing for 82,000 units? So in San Francisco, what we did is that we started taking a look at the current conditions as mandated by law, and we looked at the areas that were unprivileged and more privileged. So the map on the left is called the priority equity geographies map. Is a map that shows places with a disproportionate amount of people that have suffered environmental harm in the past, disproportionate amount of poor people and people that haven't had access to health benefits and good schools and the whole panoply of things that make a healthy, happy life. The map on the right, on the contrary, is the well-resourced areas or the highly resourced areas, and which is taken. Both maps are based on maps that the state prepares, but are adapted locally. And it shows the contrary. It shows areas in San Francisco where residents have had access to healthy air, healthy parks, and a lot of amenities that make for a more resourceful and happy and healthy life. So in San Francisco, we decided that we should make an effort in this policy creation area of writing the housing element to kind of allocate and plan for most of the growth going in the high resourced areas, the blue areas, and not in the orange areas, which are the priority equity areas, because those have been traditionally the areas where most of the growth has happened and also where most of the people are already suffering. So the idea is to try to bring some of the people who live in the orange areas to the blue areas, broadly speaking. And the housing element does that by writing very broad policy statements. It doesn't do that with any particularity or specificity. So next slide, please. The next hurdle that a local jurisdiction would encounter in realizing that policy vision is how to review all of that under the California Environmental Quality Act, or Sequa, which is a basic law that all land use practitioners deal with daily. Basically, Sequa mandates that when you're taking a discretionary action, when you're approving a project, you have to analyze the potential impacts of that project. And it defines projects broadly to be anything that is related to that action. And also it defines impacts or potential impacts broadly to be any direct or reasonably foreseeable indirect impacts. So once the lead agency analyzes the project, it has an obligation to implement mitigation measures that are feasible for any impacts that it has identified, or adopt any alternatives if those would avoid impacts. So it's a very fundamental law that all agencies use whenever they're doing anything that is a discretionary action that may have impacts. So how do we apply this law to the housing element? Next slide, please. So the broad concepts that I showed before and the blue areas, basically we said we want to allocate those 82,000 units in these blue areas. So how do we do it? So these three figures are also taken from the housing element EIR. They show how we just analyze different configurations of how the growth would go. So the red in these figures is high density and bigger heights. Like some areas in which we said, okay, these transit corridors could support higher heights and more density. And then we got some feedback from the community that it maybe didn't want so much, and so we try to spread it all more evenly and kind of spread the growth, as you can see, towards the residential neighborhoods that are not necessarily the transit corridors. So that's what we created, 3 different scenarios, and you can only imagine how complicated it was to explain this to the community. Like, this is not what we're proposing. This is just potential impacts that this housing element would take, because we haven't yet done the rezoning. The rezoning follows the housing element planning stage. So that was very complicated as a matter of like community engagement. And also as a matter of environmental review, it's really hard to analyze something that may or may not have a particular configuration in terms of, will this have any air quality impacts? Will it have any noise impacts? Will it have any shadow impacts? So I just wanted to give you this to give you a flavor of the type of challenge that lead agencies encounter when planning long-term planning documents like the housing element. So that is for me, and I'll pass it on to Ken.
Thanks, Andrea. Appreciate it. If I can get the intro slide. Everyone, it's great to be here with you. I appreciate that you have an interest in understanding land use law. I'm going to bring the developer perspective into the conversation. And the theme of my 10 minutes is running the land use gauntlet or walking the red carpet, and you'll understand what that means in a little bit. It's funny, I had to actually look up what does it mean to run the gauntlet. And I'm going to read this to you, its definition. To run the gauntlet means to take part in a form of corporal punishment in which the party judged guilty is forced to run between two rows of soldiers who strike out and attack them with sticks or other weapons. Metaphorically, this expression is also used to express the idea of a public trial that one must overcome. That is actually a very accurate description if I am running a land use gauntlet, and I'll explain why. Next slide. And a lot of this is because when we go into a city to develop a project, depending on a lot of different dynamics and factors and variables, including our own branding as a developer and whether we're seen as a friend to the community, an advocate for the community, or otherwise, I'm either going to be the hero and the protagonist, or I'm going to be the evil, greedy developer, which is when I have to run a series of gauntlets. So before I talk about more on the hypo side, just to talk about some of the factors about risk versus reward. For developers, the primary term that is central to every project is risk. And so when we talk about land use laws, we're constantly evaluating risk at different levels. Obviously, there's a legal risk of the land use law and operating within its parameters and the local zoning codes and ordinances and policies. But there's also political risk and social risk, et cetera. So the evolution curve or cycles, in some cases, of cities' appetites for outside capital investment, what I mean by that is cities that have suffered a lack of capital investment, that are wanting to start their economic engine, and if you can imagine, wanting to revitalize their downtowns, bring in different retail amenities, and also open space opportunities. They are very hungry for developers to come in and help them address their risk so that they will attract investment into their cities. Other cities, and this depends on also small city, large city, et cetera, right? So other cities that have already experienced a lot of capital investment, meaning just there's been a lot of development over time. There also has been the response to that development. And beauty's in the eye of the beholder, because some will say, oh, that was a great project. Others will say that was a horrible project. And so there are sometimes these evolutions where over time, the city's appetite or the community's appetite decreases, or it operates in cycles where they want investment at this stage, and then there's a period of wanting slower growth or no growth in some stages. And so we are always looking at where a city is in terms of their appetite for investment. And what that means for us is we're also looking at that social political climate of the city. It absolutely helps me to know someone in the city, whether it's a council person or a staff person. Having been a former staff person, I can speak city language and developer language. And so having someone in the city that I can talk to about understanding the current issues and dynamics is extremely important, because it advises me in terms of how to navigate through the process, in the entitlement process in particular. And keep in mind that before we start a project, we first have to decide, do we want to invest in the city? And there's a due diligence process when we're looking at a piece of property. So the other question is, how active is really the community? Those communities that have had lesser capital investment in the past, they're typically less organized, because the community groups typically have organized around issues or projects such as traffic issues or other concerns related to projects, including aesthetics, height, community character that they're trying to preserve. That's really important for us to know who those community groups may or may not be. The political dynamics is really understanding the city council, and not related directly to land use and real estate. Is sometimes you'll have a 3-2 council versus a 5-0 council, meaning you either have a council that's really aligned around vision, what they want in terms of development, economic development, community development over time, or sometimes you have a very fractured council, which is dangerous, because then I have to be able to count to 3 if it's a 5-person council member, right, in terms of getting enough votes for my project. But what actually is interesting is that the housing element update process, even though it can sound very mundane, for us can be very telling. And we track the housing element update processes because it's a very public process. And it will tell us whether cities are really embracing housing or not. There are some cities that absolutely want to preserve their single family residential neighborhoods, which is totally appropriate, even though there has been past legislation that have put cities on guard. But there's also the question of, do they really want density? And it is going to be very obvious in a housing element whether a city really wants to increase density, because when Andrea was talking about RENA, and I forgot how many units, it was an insane number for San Francisco, but the city's built out. So where are you going to put those units? You can only go up. So there's a question there about density, about height, about what types of projects and buildings you're talking about. And some cities just don't want that. And it really depends on where they are in their evolution. Are they a 3-2 council, 5-0 council? And we have seen cities, I'm not going to name them, that have really basically said to the state, no, we're not going to plan for housing. And the state has come down and sanctioned them and done other mean things to them. So the follow-up to that is also the zoning code update, because to implement a housing element, to be able to set the table for the units that you have to be able to plan for, you have to update your zoning code to increase densities to allow more development to happen. So those processes will tell us really, where is the city politically? Next slide. So just a caveat here. The hypo is not going to be just one project through each of us, by the way, because I've never done a project in San Francisco, nor do I. No offense, Andrea. But you have two speakers here that are from very large cities, Los Angeles, which is Helen, and San Francisco, which is Andrea. These cities are have a lot of development, and you'll see that in the numbers that they share. But these cities also are very difficult to navigate politically, but also in terms of some of their procedural requirements. It's different than smaller cities, which is predominantly the cities we work with in the San Gabriel Valley. The example that I want to show, though, because it really doesn't matter actually where we're locating our project, because I have to do a full evaluation, just like I said on my prior slide, about do I want to really develop in a city? So there was a property that we bought in 2016, and the land acknowledgement was very interesting because we have to definitely acknowledge the history of the property that we are developing. And this particular property is a 6-acre property in the San Gabriel Valley. It's a 100-year-old nursery that was owned and operated by a Japanese immigrant family that was interned actually for a period during the life cycle of their nursery. And the nursery is actually still operating. This was their wholesale growing grounds, which they decided to sell. We're also working with 2 different California Indian tribes that are recognized by the state, but not the federal government. And there's dynamics there, trust me, because those tribes also have a history with that Japanese family over time as well. And so these dynamics are very important for us to understand. And so when we go in, we will be in dialogue with these different stakeholders to understand that history and the dynamics of that. So community opposition to mixed use, it was interesting coming into this property because staff advised us, even when we were contemplating purchasing the property, that there had been opposition to high density mixed use projects, but not for your traditional reasons, purely around traffic and density and height, et cetera. It was actually really more about racial discrimination. And so there was actually a opinion paper that the city attorney wrote that told the council, you can't back this ballot proposition because it's being proposed by a group of residents that basically don't want to see their city, I'm just going to say it, become more Asian, right? And so this particular city has had a lot of transition over time. And so there was a purpose behind that. So for us, as my boss is Taiwanese, this was important for me to understand because as I'm going in and working with stakeholders, there's a context for this. And so the entitlements and the types of entitlements that are required are very, very critical to our decision about how we're going to proceed. Because if it's a by right project, meaning when Andrea talks about zoning code general plan, if the table's already been set for our type of project, then that reduces our risk tremendously. We are a by right project under the rules of engagement that the city has set out. But if we require discretionary approvals by not just a planning commission, but also a city council, which was the case here with a zone change that included I'm just going to throw these terms out, you may not know what they are, but plan development overlay, a development agreement, which is a negotiated contract. And then there's kind of the more boring stuff like the tentative track map and precise plan of design. But this was significant. We needed to know that the community would back us so that the council would be able to approve and know that they have cover to approve this project. Next slide. So I'm not going to spend time, I'm not going to explain this. I'm going to explain that it took us more than 5 years to get our project entitled. That is not normal. Typically, developers are looking at 18 to 24 month timeline. This was more than 5 years. Yes, it was during COVID. That was not a factor. But basically what you're seeing here is a lot of community engagement. We spent a heavy amount of time and resources in community engagement, which was critical. Next slide. So this is just showing, and that's me. But we did 3 workshops just in the first year. I talked with over 20 stakeholders, both people that wanted us, people that didn't want us. It was important for us to understand the dynamics here. Next slide. We did even community pop-ups. This was just as COVID was ending, so people were, ready to come out. We had popsicles there. We had free food. It was actually a really successful event, but it was really to be able to re-engage the community after COVID. Next slide. All that to be said, what we really tried to focus our community engagement around is focusing the community's attention on what are we actually bringing to the community that they want. Open space. We have a large central park for community gathering and special events. Retail amenities, 70,000 square feet of retail, aside from the housing, which was 251 units, but the retail in an area that was sorely underserved from a retail standpoint is important for them. The history, back to the Japanese family, that in the nursery, we also have public art built into the project's design that's a tribute to that family and to the history of the property. Next slide. So this is eventually what the project will look like. We are under construction right now. Let me just explain when I talk about risk, there's financial risk. That 5 years translated into over $5 million in investment, which was about $2.5 million in architects, engineers, consultants, $500,000 in Sequa, which took 2.5 years for our EIR. The other $2.5 million, guess what? We spent on property tax. That's carrying costs for the project. Next slide. And so where I'll end really is that the rules of the game are changing constantly. And so if anybody follows land use law, there's constantly housing bills and other bills that are really starting to tie the hands of cities, much to their chagrin, trust me, because there are issues, and I'm not going to go into detail because I'm running out of time, but these are just examples of some of the tools that developers can use to really actually push their projects through if it's a housing project. And that's SB 330, the builder's remedy. You may have heard of that in the news, where a city is not in compliance with their housing element. SB 35, we have one project that is using that, which is purely then requiring the city to have ministerial review, no hearings whatsoever on the project, but there's affordable housing requirement as part of that. I am going to hand it off to Ryan, and hopefully during Q&A, I can re-engage.
Thanks so much, Ken. And by the way, I just have to compliment you on the incredible public engagement part on the front end. You, for my part in our hypothetical from various different perspectives, today I am going to take the role of the project opponent. And this is not typical for me. My practice almost always involves working with people like Ken on projects, trying to get a project entitled and working it through the land use and Sequa process, and then defending a project in litigation if necessary. So this is I'm putting on a different hat than I normally wear in my practice. So it's kind of fun, right? Get to play a little different role. But I wanted to emphasize the part about Ken's initial engagement with the community. Now, what did he mean by that community? Who is he trying to engage with during that period? And I go back to here, this concept of a land use process not being binary, right? It's not the project proponent and the jurisdiction or the agency with jurisdiction, like a city or a county. it is not just about those two parties. They may be central players, but there's a lot more folks that are going to come to that party who may be interested in that development proposal. Well, lots and lots of people may be interested in that project, and I've listed a few on this slide, starting with the politically elected and appointed people within the agency that's having jurisdiction. You're going to have perspectives within the staff that's working in that jurisdiction, as well as the elected folks who may be looking over staff's shoulders at things that are coming down the pipeline towards them. But we also can't forget about other agencies that may have a role to play. I'm talking about resource agencies like potentially the California Department of Fish and Wildlife, the Coastal Commission, potentially, if there's a coastal jurisdiction issue. You may be looking at federal agencies that have certain levels of jurisdiction, regional agencies like a regional water quality control board. I'm throwing out lots of names that may be a little unfamiliar to you. I'm just trying to give you a sense of the idea that there may be lots of other agencies involved that may have some specific role to play with respect to the project that aren't the city or county. Also wanted to point out, I think when Ken was talking about the public outreach that they went around to, I think it looked like he was trying to talk a lot to the community, and by that I interpret to mean the neighbors, the future neighbors of that project, right? Who lives next door? Who has a business next door? Who lives a block or two away? Who commutes right by through this corridor and may see additional traffic impacts? These are the folks that I would consider to be in that first tier neighbors, right? There may be other neighbor-based or community-based groups that have an interest. Most cities have, and most counties have, certain planning entities, community-based planning groups that sit and help advise the city and or the county as to projects that are being proposed and kind of coming through the process, the development process. Those community-based planning groups are composed of interested citizens, and that may have been one of the first places that Ken had to go with his project to start to gather support. It's also a place where folks that are interested in keeping the status quo or interested in the community kind of keeping a certain character, they may be on that committee intentionally to flag projects that they do not want to see come into their community. So that may be one of the first points where an objection may start to arise. There may be competitors who are also seeking a competing project or a project that already exists that doesn't want to see something new coming in. And I haven't yet even got to folks that may be in what we consider and have an environmental resource area that they're trying to protect. A group like the Friends of Insert the Blank, right? Or if it's a coastal issue and involve a coastal project that's involving coastal issues, maybe it's a coastal resource group that is focused on maintaining access to the coast or to protecting biological resources in one particular place. Now, and then I'm not really framing these the media up as a potential project opponent, but what I would say is that if your project is of any particular size, the media will have an interest in that, right? And the public at large. And how that story is going to be told through the media will be something that will happen at some point and may be influenced by any one of the various groups that I've got on this slide, and then others that I haven't even included. So who's coming to this development party? Well, it could be packed, right? There could be a big tent of folks who are interested in this project, and how are we going to engage with them? That's a really interesting question. Can we turn to the next slide? So I've left a couple blanks on this slide intentionally, right? I didn't want you guys to think that I just forgot to finish this slide. So how does blank engage with all these parties? Fill in the blank. how does the proposed developer engage with these parties? How does the city engage? How do all these resource agencies that may have a role engage with these parties? Or do they ignore them? I tell my clients that the process of going through a land use entitlement and Sequa analysis, and I loved your definition and use of the gauntlet. That it was just so great. I tell them it's a radical public engagement process, and they should just get ready to embrace that process. I'm not sure if this is possible, but Andrew, would it be possible to flip back to Ken's slide number 14?
All right.
Sorry, I didn't flag this up in advance, but I wanted to focus in a little bit on the schematic that he proposed, or he created there, that big map with the timeline on it.
Sorry, I'm having a little trouble getting back there.
Well, one of the things that really stood out to me about that slide is how much time throughout the entire process, there was always some sort of community engagement and public messaging milestone that was occurring. Whether that was the initial community involvement, when there was, broadcasting this idea to the community and doing, I guess it was receiving a lot of feedback. And then even once the EIR process started, which means that you have a relatively well-defined project, there was a period where a feedback could be given back to the process, and conceivably affecting the design. Yeah, you're almost there. There we go. Stop right there. One back. There we go. Do you see on the slide, there's a yellow highlighted box that's described it as design refinement? In every Sequa or land use project I've ever been involved with, there's always this process of design refinement. And this is a process where it may be because you're defining or developing more information about the proposed project. It may be because you're getting a lot of feedback from the community, or from potential folks that are opposed to your project. Now, putting on my project opponent hat again, I want to be involved from the very get-go, right? From the very, very beginning of this process, because that maximizes my opportunity to use the Sequa and land use process to make this developer run the gauntlet, right? Every time I submit a letter, every time I speak at a public agendized meeting, every time I talk to somebody in the media or go and speak with politically elected representatives' offices, every one of those every one of those particular touches is another way to make it more difficult for the project to get through the process. So understanding that, I think Ken, here in this project that he is laid out here, did a really good job of trying to do public outreach in order to, I don't want to say diffuse, but to embrace the public process and to create an opportunity to build trust and then overcome objections. What I would say is that ignoring the public process in the land use development cycle is something you do at your peril. Andrew, I hesitate to ask, but can you flip forward to my next slide? So one of my early mentors, when I was just starting to practice law, talked to me, or he said that what we're striving to do as legal practitioners is to practice law in 3 dimensions, try and be a 3-dimensional lawyer. The way that what he meant about that is that I'm not just trying to understand what it is that my client wants me to accomplish. I'm not trying just to understand sorry, there, my light turned off. I'm not trying to just understand what the counterparty across the table from me in this development context, let's say it's the city, what their goals are. I'm also trying to understand the goals and potential objections and the way I can affect them or they can affect me of all the other interested parties that are coming into this land use process and may have an opportunity to affect my ability to achieve my client's goals. In this part of the hypo, my goal is as project opponent. So I want to make the project run through as tough a gauntlet as possible. How do I do that? I can't say it enough. The Sequa process is probably the most difficult part of the land use gauntlet that a project opponent can focus on to kind of ramp up the level of difficulty. A next key point of interconnection would be the political point. You might have heard Ken saying, I need to be able to count to 3. So if you have 5 city council members, to get to a majority, you need to have 3. You have 3 votes, right? So if I am able to winnow away, that 3rd vote and turn that project to a 2-3 defeat, that's another real big point of interconnection. And then, it never hurts if I can reach out and win in the media to tell a story that is very highly negative to the project. That's another way that I can really start to shift the narrative. Now, lastly, and I left this lastly, even though as lawyers, we sometimes want to go to litigation first because it's the hammer that we're used to. You always can litigate, and lots of Sequa litigation have been filed against housing projects throughout the state. It's been actually almost like an epidemic. And a word on litigation, and then I'll pass this over to Helen, is that lots of folks in my experience, folks have felt, I've seen people rely on litigation as the way that they are going to defeat the project. And the process of going through Sequa or land use litigation is definitely one that can slow a project. You can actually win a battle against the project. You can make them go back to fix issues in a Sequa document. You can make them go back and even get a renewed political approval of the project, which are not small things. But if the project is supported with sufficient political support and the developer or the proponent of the project has enough money to move through the process, they ultimately will succeed. And litigation will only win you the battle. It won't necessarily win you the war. So there are limits to the litigation process that can be quickly reached if you're not capable of affecting the other core aspects of project approval. Importantly, whether or not there is or is not political support. All right, I'd like to pause here. Helen, can I pass to you?
Sure thing. Yeah, thank you for that, Ryan and Ken and Andrea. So just here to promote and to basically talk about the elected officials' perspective. I think all of the panelists really highlighted how important it was to really get that political support early on. And I just want to share, as the planning director for a newly elected LA City Council member who really beat out an incumbent. She's young, ambitious, she's 32. She really ran on this platform of change. But there's, even though we want to create some change, it takes time to create some change. And so I think that, one of the things in terms of, the elected official is just really understanding where they're coming from, who their constituency is, and, where they are in terms of their ambitions. And so, I work for LA City Councilmember Ulysses Hernandez. And so you can go to the next slide. And so we really ran on a progressive platform. She really ran on a progressive platform to really start to listen to her constituents and have ground up perspectives that would fuel policy. She ran on a platform of equity, of making sure that we would increase affordable housing and really focus on disadvantaged communities while striking a balance and promoting growth, while, you know, in order to ameliorate the housing crisis and the climate crisis, as well as to really focus on criminal justice. And so, you know, she is really passionate, and she's a really, like, her community very much supports her. And so it's a very dynamic community. And on the LA City Council, we're one council district of 15 council members. And so, you know, in order to be really progressive, it takes a lot of work to really try to convince folks sometimes to come to your side, especially if you're atypical. And so that's just one of the challenges we have because of why we're here. And so I think that for us, in terms of planning, I think, you know, I came from the state perspective. I was at the governor's office of planning and research for 4 years before that, and understand, you know, like all of these wider kind of issues. And now that I'm, you know, back at the very hyper local level, it's really, I think, important for us to ensure that the neighbor, the constituent who is expressing a concern about a development project next door to them or on their block needs to understand how that development not just has an impact for them, but what it means for the wider region, right? And so that they understand also, like, all of the local, regional, and state laws that are in place in order to be able to move certain developments like this forward, right? And so I think that's been really important, because it takes time. You know, I think folks understand that we have like a really giant homelessness crisis, right, in the state, especially in LA. And so, you know, we have a lot of folks who often will say, I want you to solve the homelessness crisis, but don't put them next door to me, right? And so we have that a lot. Even though you may be across the street from transit, you're in a very non-fire hazard severity zone. It's really safe to put people there, and, you know, but that's next door to me. So we do deal with that a lot, and I have empathy for that too. And so we try to really like strike that balance. I think sometimes too, just the size of the projects, right? When you have local density bonus laws coupled with state laws that really streamline housing development, because we have a shortage of planning for housing and building housing that we need, right? We don't have enough units. What does that mean? That means that you can't really stop a project sometimes. You can't have more than 5 hearings if you're adhering to SB 330 and its extension SB 8, right? And so we need to kind of explain to the community, we're going to do everything we can to really work with the developer, work with the opponents, come to a place of understanding and agreement, and get this project better than it was going to be. But we also have our hands tied. And I think, you know, in the past, council members and commissioners had more and more power to say no to projects, even if they met all of the objective standards, even if the developer was responsive to the community. If the city council member said no, then the project would die, right? And I think the state has tied our hands in that respect. And so sometimes, like, you know, now that like we're newly elected and people are like, wait, I thought you'd come here to stop this project from coming next door to me. And it's like, well, it's an affordable housing project, right? Like you said, you wanted to fix homelessness and you wanted to work on, you know, climate issues, right? This is a dense project across the street from transit. Let me show you how all of these state laws are really impacting our decisions. And let me tell you where we have power and where we're going to help you leverage, right? And so, you know, we're there to really explain things to the community. And I think also a lot of times these policies they're very well intentioned, but there's a lot of unintended consequences. And so a lot of times you have the opposite, right? You have like the NIMBYs, and then you have the YIMBYs that are like, you know, we need housing development at all costs at all transit stations. We need to really fix this climate crisis now. And the one solution is to build but as a council member, or as if you're really close to the ground, you'll notice that there are no protections sometimes for commercial tenants that made up the fabric of that community, that had been there for 20 years, right? All of a sudden, there's zero protections from them. They're gone. It's going to be a new business. Maybe it's more corporate, right? Maybe it's more like cookie cutter, right? And it's not as unique as it was. It removes the flavor of the neighborhood, or there's like a new flavor that's going to be there. And I think also you have residential displacement too. And even though you may have local laws that really are supposed to protect displacement from happening, or you have payments that go out, they're never high enough. It's never, it seems like it's never enough. There's a lot of ways people could fall through the cracks, right? And so that's really what we deal with on a regular basis. And I think that, from once you're sort of like at this sort of space, by the time a project gets to you, there's already sometimes like some conflict. And so you're having to resolve that conflict. I think the other thing to be aware of is just that there are there's patterns of appellants, right? You'll see the same players over and over again. And it's really important to kind of familiarize yourself with like what they're doing. I think, Brian, that point that you brought up about like Sequa being weaponized is very, very endemic, right? We see it a lot. I think it's because it's sometimes the only opportunity for any group to really be heard, right? And so I empathize, but at the same time, it doesn't have anything to do with the environment. You see this a lot with labor unions sometimes, and I'm all for labor unions, but they're asking for one thing, and Sequa's the only opportunity, and so then it sort of forces a negotiation. So it's really tough. And I think a lot of what you deal with at the elected and at the local level is all about like conflict resolution. If we could go to the next slide, Andrew. So I think that as Andrea mentioned, the city of LA, like our RENA allocation is 456,000 units in the next 8 years. And so we have a few policies that have been put in place in order to be able to try to help get there. And we have two density bonus laws. We have the state's density bonus, SB 1818, and then we have a local transit-oriented communities density bonus program that really voters passed in 2016. And so this was something that the city didn't come up with. It was the voters of the city who said, we want you to address affordable housing, but we don't want taxpayers to subsidize that housing. So what does that mean? It means that for any development that's in a certain proximity of a major transit stop, you will get certain density bonuses if you have like a certain percentage, like 8%, 10%, 11% affordable housing. And you can get like a 50, 60, or 70% density bonus. And the idea is that the market rate units from that density bonus will subsidize the on-site affordable units. And, this also like coupled with, you can't have no more than 5 hearings for these types of development projects, really puts communities that have a lot of transit like ours at like a little bit of like working on a defensive posture, because we see so many projects like this. I have entire blocks in like MacArthur Park, Westlake, that is like a very historic community that's next to transit, very dense. And it's just like, sometimes like 1 week it'll be one address, the next week it'll be the next door address, the next month it's down the block. Like I have entire blocks that are changing at the same time. A lot of people are being displaced at the same time. And so when we really try to like, I understand that we need more housing, and I understand that we need it by transit. But, when we're like trying to be as responsive as we can to the community, it's translating all of this technical information, but then it's also translating like, what the community is really feeling back to, like the planning department, the planning commission, the planning and land use management committee members, and the rest of the city council members to kind of side with you or not, right? And so TOC itself, and coupled with density bonus, is responsible for about 45% of all housing units in the city of LA, and 60% of its affordable housing. So there's just some numbers there. If we could go to the next slide. So conflict resolution, I think, one unique point for newly elected officials, I think, is that during the pandemic, a lot of cities basically halted the time period for hearing cases. And so sometimes you have certain local laws that say, okay, if you file a case and there's an appeal, you have 90 days to hear it. Well, during the pandemic, those appeals were held for like 2.5 years. And all of a sudden in 2023, cases in the city of Los Angeles that were held since 2020 sometimes, and sometimes those were the most controversial cases. When we inherited the office, we inherited all of those problems, and we had to hear them all no later than like May 2023. And so we had like 5 months to really like deal with our most complex projects. And sometimes like those communities were really upset about like a 7th-floor building coming next door to them and them trying to work with the previous office and not being heard. Sometimes developers are like, you know what, these are my minimum requirements. You don't have to force me to do anything more, right? And so as a council office, you're really trying to listen to the community and just advocate for the best outcome on a case-by-case basis. Sometimes all you have is freedom of speech as a council office. You just have to make a very convincing and compelling argument for the developer, sometimes to listen to like what's happening in the neighborhood, what's happening in the community, to really try to figure out, you know, these are families that are going to be displaced. Our minimum requirements are X. Can you give a little bit more? A lot of times, most of the times developers are like, no, these are my minimum requirements. Sometimes they'll like be, okay, I'll give you 5% more affordable units, but they're going to be at 150% AMI. I'll take it, you know? And so like, these are just types of, but like we try to work every single case, but as Ryan said, that like leads to a lot of unpredictability sometimes. Well, you have the predictability of like these state policies, but you know, like who knows if you're going to be able to make that argument, right? And a lot of times too, we'll listen to the community, and you have to really kind of hear what they're really afraid of. Sometimes they'll raise a big concern, but it's like, you know, is it a fear of change that you have? Is it a fear of a certain income of people that are coming into the neighborhood? Why? Why do you feel like people can't come into your neighborhood? Why are you closing it off, right? And so I try to also tell the community too, like, you know, have them and help them understand about like, we have a lot of people that we need to house. The city is always growing. These housing units are for your families too. So it's really tough. I think the other part is just advocating for policy change once you hear about a lot of these concerns. And so we have a lot of ideas that we're starting to work towards to amend TOC, which sunsets in 2026 and needs to be renewed in a new way. So we're working on that. And I think the other part is just harm reduction, right? I mean, there's only so much you could do sometimes when your hands are tied. And so, especially for those commercial tenants that are being displaced, we have, you know, sometimes we've had like a Dollar Mart and a swap meet of vendors who've been there for like 20 years. And then now you have a TOC project that's going to add affordable housing, add new commercial space, something that we all need. But at the same time, those folks have zero protections. And so recently we helped a group of swap meet vendors. Really, we facilitated a conflict negotiation set of conversations with the developer, the architect, and their attorneys to try to come to some agreement, give them extra time, try to work out some responses. And then in the meantime, we connected them to eviction defense services to really try to help out beyond the ways that the city could help out, that the council office could help out. And, you know, then we presented that to the City Planning Commission just to talk about how, you know, we did respond to as best as possible to their concerns, but, you know, there's only so much we can do. I think the other part that we try to do is always just connecting folks to resources, right? That's sometimes when there's unintended consequences, you know, there's just only so much you could do, and there are lessons learned to make policy change in the future. If you go to the next slide. I think that the other part that's important, I think for all of us in our practice, is just really celebrating our collective wins. You know, we need to make sure that we're always like, these are long journeys, these are hard journeys, and this is like work that we all decided on, but it doesn't have to be so arduous. And so, you know, we need to translate progress to each other, to the community, and celebrate. And I think it also is really important to energize people and constituencies for that next step on the journey. And I think the idea is that like we want a lot of engagement, but we want it to be in the right direction. And so that just takes a lot of work, and it just takes a lot of organization, right, amongst all of the the advocates, the opponents, like we're all, you know, just having to work together. This is one project, maybe the next project we could be allies, maybe there'll be a better outcome for the next project, right? So you got to celebrate like those wins as you go. I think it's also really important that we celebrate collective wins, publish that on social media so we can inspire other communities and help other communities along. You know, maybe there's lessons learned in some cities in one part of California that we need to translate to others, maybe on other parts of the country or other countries in general, right? And so I think that's really important to remember to do. I think it's also just important to connect together and to have fun along the way. And I think this is a photo the council member really championed a measure J in LA County, which you wouldn't think is related to land use law because it was about, you know, making sure that a portion of locally generated taxpayer dollars at the county were spent on alternatives to incarceration. And so while land use folks are like, oh, that's criminal justice, that's different, it's not, because the homelessness crisis affects everybody, right? There's homeless folks on our streets, on our transit systems. And so it's like, how are you going to be able to shape the built environment if like all of the folks that are on, you know, your public streets need an alternative, need assistance in different ways. And so, you know, just making sure that we're connecting all of the wins back to land use and because everything's interconnected. And yeah, that is my last slide. So you could go to the next slide. And I think we're open for questions now, right? And oh, and these are just some helpful resources that we put together for you that we thought you would find the most helpful.
Great, thank you. Thank you to everyone on the panel, Andrea, Ryan, Helen, Ken. Really great, broad range of perspectives on some really important issues. So we do have a little bit of time built in for Q&A. We have a couple of questions that have come in during the presentation. If others have questions, you can put them in the Q&A chat as well, although our time is a little bit limited to get to all of them, so we'll try to get to them in the order they came in. So first question is, are any of you familiar with what happened in La Habra and why there was a lawsuit regarding the housing complex that would have been built on a golf course and the Supreme Court upheld the denial? It seems like with the housing and environmental crisis, golf courses aren't the best use of land in urban environments. Anyone want to jump in on that one?
I'm vaguely familiar with this project, just because I know the Orange County area a little bit. It's a large golf course, let me just say. And earlier when I was talking about small towns versus larger cities, when you're talking about a golf course that large with a pretty substantial development, which was looking at 530 new homes in La Habra, which is not a big town, like I said, that's significant. And it's on hillside, which is very sensitive in North Orange County, where there's a lot of efforts to protect hillsides. And so a lot of times it's in the name of environmental protection, et cetera. It's really for views and, you know, preserving community character sometime as well. I'm sorry, that's a developer perspective. But my understanding is that this has been a very long saga, and it's a Lennar Homes, which is a very large national builder, by the way, very reputable. But the city council ultimately, because of the community opposition, denied the project legislatively at the city council level. And then they turned around and they put a ballot measure up that basically put it in the voters' hands of whether voters would approve the conversion of open space land. And guess what open space land is in La Habra? It's the golf course. So there's a number of issues that have transpired over time. I don't know about the Supreme Court upholding the denial. I think that just happened maybe this past week from what I understand. But I don't know how that relates to the builder's remedy application. I know that Lennar was pursuing as well, because the builder's remedy, and there will always be a dispute potentially over whether the builder's remedy applies to their project. But that it would be interesting to know whether they are still pursuing the builder's remedy. But that's as far as I know. But that's a good case study of all the issues that we talked about. In fact, but I don't disagree about golf courses not being the best use of land in an infill environment. If it's a municipal golf course that the city owns, I mean, those golf courses don't really make a lot of money for cities. They're usually losers financially for cities. So usually they're looking to redevelop them. But in order to redevelop it as something other than development, I mean, it can only really be a regional park, which is more cost than income for the government entity that's going to own and operate it.
I just add to what Ken said, that was a really great summary, is that it's from a legal perspective, it's very difficult to overturn a project denial by a jurisdiction. That's a steep hill to climb right off the bat. Beyond, it sounds like a widespread community opposition to the project. I don't have any personal knowledge of that. I just wanted to add that key points to starting off trying to turn around the decision by an elected body is you're already starting at a significant disadvantage.
Okay, other thoughts on that question, or can we move on to the next one? Okay, so the next question is, how do we stop the city from upzoning open space like the hotel in Benedict Canyon when we are facing a climate crisis and there's vacant land or lots that could be used in the city versus luxury hotels and mansions?
I can take that one. I think that goes to the topic I was talking about first, about the general plan having a horizontal consistency requirement and all the city policies needing to be considered at the same time. You know, every action needs a general plan referral and consistency. And clearly the participant has identified a conflict between open space values and climate change adaptation policy and housing. So those are the kinds of conflicts that should be the community and the city should identify to kind of try to sort it out. Then maybe there's a compromise that also times maybe the development can be in a small parcel. Maybe if it's a hotel, it can also have other community serving benefits or amenities, like to the points that Ellen was making. You know, maybe the zoning can be changed so that there's a little bit more kind of taking into consideration of the different goals. But definitely from the point of view of the public agency, these are conversations that are really hard because policy goals are often in conflict. And it's impossible to really do good and 100% by everyone and all policy goals. And they're all legitimate, of course.
It's really well said, Andrea. I'll just step in too, because that was a LA City project. And so I think ultimately the city council was very split on it, and there was a tied vote. And then they had to take another vote after more information was shared and after more debate was had. And then they voted to deny the project. But as Andrea mentioned, you know, I think in terms of advocating for, you know, your viewpoint to really like make sense to the council member, to the city, it's just about getting there early and just really connecting with your local officials that are going to be ultimately taking that vote, and just having your voice be heard, right? And just to make sure that you know, they understand where the community is, where all of these other, you know, these larger concerns are, and that could also maybe combat forces that are for that development, right? So I think it's just about advocacy, especially because that was a very big discretionary kind of action that needed to be taken, and it was almost going to go through right until the very end. So hope that answers the question.
If I can add one other thing, just in general about the past two questions, is some of the challenges come where a project, I'm just going to say, runs the gauntlet. And a lot of the new legislation that has passed and is now in the government code has to do with how many hearings you can take a project through. There's another project here in the San Gabriel Valley, I'm not going to name which one, because it's highly contentious, over 1,000 units in a critical area near transportation. But it went through 25 hearings, and then they ultimately voted no. And so there is a builder's remedy application for that project. The interesting thing was that in the city's draft housing element, they were counting all of those units toward the RHNA goal. And so it was interesting dichotomy that was happening there. So I just thought I'd share that.
Great, thank you. I'm keeping an eye on the time here, so I'll try to get to as many questions as I can, and I'll apologize in advance for anyone whose question I can't get to just based on time constraints. So the next question is, and this is a fairly significant big one. What is the progress on the movement to get rid of single family zoning and deal with redlining? And I know we're don't have a ton of time on this, but if anyone wants to jump in on this significant issue, please do.
I'm happy to go first, just very short. I think the biggest movement or progress on that end has been the acknowledgement that single family zoning is intrinsically exclusionary. That sentence could not have been uttered 5 years ago without like it being contested as super political and what are you doing, and that's not true. Single family zoning is like the American dream. Has all this legacy, but now we finally understand that land is finite, and that when you divide it up in ways that very few people can use it, you're going to not be making room for other people, particularly in jurisdictions that are land constrained, like San Francisco. So just to me, aside of the law, just the cultural acknowledgement that we've come around, I think there's a consensus now that this is not an efficient use of land. It's still, as Ken was saying, very much well regarded and people want it in many ways. So it's a difficult process politically to navigate, but at least at the state level, we have passed laws that make it possible to not be constrained by single family zoning. So even in zones that are through SB 9, which was passed a few years ago, even in zones that are technically zoned as single family zones, property owners can develop up to 4 units. So in terms of the law, we've been liberalizing it. And in terms of the culture, I think there's been a great shift.
Great. Thanks, Andrea. Ryan?
Yeah, just adding on to what Andrea had to say, SB 10 is another notable state law that was passed. It's an opt-in law that would allow up to 10 units to be built on a previously designated single-family residential lot. But it's an opt-in type of thing. I'd also want to mention that there's a substantial movement to allow ministerial development of accessory dwelling units, ADUs, and right here in San Diego that we embrace that. There's lots of ADUs moving into single family, what was previously only single family residential neighborhoods to densify. So there's been a lot of different measures that have been taken recently to address the housing crisis. I just want to say though that I think that there's a substantial backlash building to at least to the attempt to widespread abandon or to wipe out the single family zoning. Here in San Diego, there was currently pending a proposal in front of the city council to opt into SB 10, and the planning commission, in part potentially responding to some pretty widespread protests in the city, opted to, recommended the city council not opt in, and to do other things to densify housing and address the housing crisis. So I just had to say that it's certainly not in there's certainly a lot of energy still being seen in that area.
I think just one more thing to add really quickly from the state's perspective is that one of the 5 statutory requirements of the regional housing needs allocation is to consider affirmatively furthering fair housing, which means that you're supposed to allocate housing in areas that have high opportunity areas, and those are typically areas that have mostly single family zoning. And another thing that the state did really with the requirement to develop an environmental justice element, if you have a disadvantaged community, is that your environmental justice element is supposed to be created at the same time that you update your 2 or more elements. So if you update your housing element, it triggers you updating a safety element. And if you update 2, you have to update the EJ. And all of those things are supposed to be sort of considered together in order to mitigate the effects of redlining, right? Where many low-income communities were forced to live next to areas that had like industrial hazards, right? So that's just some of the ways that from a planning state perspective that they're trying to address it.
Great, thank you. I think we have time to fit in one more question. And again, my apologies to anyone who has questions that we won't have time to get to. But well, let's go to this last question. Can you talk about the dynamic of navigating a process in which the Planning Commission is not on the same page as the City Council?
I'll give you the developer perspective because I've been through this process. Just keeping in mind that ultimately the buck stops at the City Council, right? And so I will say that in terms of dynamics, because the City Council appoints the Planning Commission, it's rare that they're completely misaligned, but there are occasions where that can occur. And so when I talked about by right projects before, there's no such thing, because we did take a by right project to a Planning Commission who denied it. They made findings which were questionable. We could have appealed it to the City Council. And so remember that every Planning Commission decision is appealable to the City Council. We, in that case, chose not to appeal that particular decision. But that's important to know, because anyone can file an appeal of a Planning Commission decision. It just takes one resident. We've been through many appeals and appeal hearings that have gone to the City Council. And so if the question was a little bit more about the other dynamics, I would probably need clarification on that, but I'm sure others can speak to this as well.
I just wanted to say something very briefly from the point of view of an attorney serving in a local jurisdiction. The client is the whole local jurisdiction. So we as attorneys have a duty of confidentiality and all of the other legal duties to each of our clients. And those clients often are at odds, like in this question. And I just wanted to highlight that's a really difficult position to be in, but we basically owe each of our clients our full attention, and we have to respect the confidentiality and not share any private, attorney-client communications with the other members of the other entities within the city family, which may be at odds. So that's something that poses, I think, extra kind of interesting challenges when you represent public agencies.
Great. Thank you for those responses. I think we're going to wrap up Q&A right there. But before we wrap up the program in its entirety, oops, I lost the page there. I did want to mention a few things about ways that people who are watching can get involved in either CLA generally, or the environmental law section, or the new lawyers section. We have a slide in the materials, which will be made available, by the way, just discussing some of these ways to get involved. Obviously, joining the sections is a good start. Both sections have webinars, in-person events, and webinars like the one today, as well as the environmental law section's upcoming Yosemite conference, which I mentioned earlier. There are some great MCLE self-study materials available through both sections. Both sections have mentorship programs. The environmental law section has a great diversity and inclusion fellowship program for summer internships. And of course, there are job boards available. So we'd encourage you to get involved in any of those ways. With that, I would like to thank everyone on the panel here for just a great broad range of perspectives and really interesting thoughts on some of these big issues. You'll see there on the slides, there's contact information for anyone who might have follow-up questions about any of the discussion today. And in addition to thanking the panel, I'd like to thank everyone out there who took time out to join today. We really appreciate it. And we hope you will join us for some future events. Thanks so much.
Thanks, everyone.
Thank you. Bye-bye.
Thanks, Andrew. Thank you, guys. Take care, guys.
Bye.
Bye.